My name is Courtney Gerber. I use she, her pronouns, and I am MCM's Program Director. And I want to thank you for joining us today for some knowledge building around liability, specifically through the lens of COVID-19 and its impact on nonprofits. Before we introduce our speakers, I would like my colleague, Shannon McCarville, to offer a few tech notes to you on how the webinar tools will run today. Shannon.
Hi, everyone. Just quickly want to call your attention to the Zoom tools you'll be using today to engage in this session. First, look to the bottom of your screen and click on the chat and Q&A buttons. In this session, the chat function will be for you to communicate with the group. So feel free to share your thoughts and comments. Just be sure in the To field, you select all panelists and attendees so everyone can see your comment. To ask questions during the session, please use the Q&A function. You'll also be able to upvote a question you'd like to see answered or comment on a question. I'm now going to turn it over to Andy, who's going to talk about accessibility options.
Hi, everybody. My name is Andy Sturdivant. I'm Artist Resources Director at Springboard for the Arts and coordinator of the Minnesota Lawyers for the Arts program. This event is being live captioned, so if you go to the bottom of your screen, you will see an option for closed captioning. You can toggle that on or off by selecting Hide Subtitle or Show Subtitle. And you can also see a full transcript as well. We will also have an ASL interpreter joining us shortly, and when she joins the call, we will introduce her quickly. But when she does, her video will be spotlighted, which means it will stay on the screen so you can see the interpretation as it's happening. And now I will be turning it back over to Courtney.
Great. Thanks, Shannon. Thanks, Andy. Before we get started, I have a few words to share about our speakers. Rebecca Bernhardt is a partner at Dorsey & Whitney. Rebecca's experience spans traditional labor and employment counsel, immigration, and federal contract compliance and audits, including affirmative action plans and audits. Rebecca is Dorsey's Diversity and Inclusion Co-Chair. And Rebecca is joined by Trevor Brown, who is an associate in Dorsey's Labor and Employment Group. His practice includes providing litigation support on employment issues that arise under state and federal law, as well as advice and research for clients with employment-related legal questions. Both Rebecca and Trevor collaborate with Legal Corps, our partner on this webinar, to offer pro bono work, something that is near and dear to both of them. Rebecca and Trevor are going to be joined by my colleague, Ileana Mejia, MCN's public policy advocate. And Ileana is going to moderate the Q&A portion of the webinar. And you will learn from Rebecca when I turn it over in a second. We'll have questions sort of at various points throughout the presentation and then save some time at the end as well for some back and forth with the presenters. So with that, Rebecca, I turn it over to you.
Thank you, Courtney, and thank you everybody for introducing yourselves and for being a part of this today. Trevor and I are really happy to be talking with you all. We have both have a pretty big commitment to providing pro bono services to all of our nonprofit community friends here in the Twin Cities and elsewhere. And it's through Legal Corps, and I know that there's a couple board members on the program as well. So hello, Gina, and hello, Alyssa. Legal Corps is one way we partner at Dorsey with folks, and so they were helpful in getting us together with you all. They provide kind of business and nonprofit support to folks, and they do it in a wide range of what I will call transactional issues. So, for example, employment services that Trevor and I can provide, but they also have, real estate leasing attorneys, and they do it currently in the COVID world. They're doing it via telephone counseling, but they used to have drop-in clinics, and that's how I first got in touch with Legal Corps, was back when you went and sat in a drop-in clinic. But they do a great job in the community, and we're really happy and honored that they asked us to talk with you today. Trevor, thanks to Trevor for helping prepare the actual written slides that we're going to be working on, and that's my understanding that you'll get a copy of this. We really want to make this interactive, so we might not get to every single slide in all of the detail that it looks like on the slide, so we hope that it provides a nice written resource for you afterwards and alleviates your anxiety about having to take notes while we're talking. With that, Shannon, if you want to go to the next slide, that would be great. Um, so we have a very sort of modest agenda. We want to talk about COVID-related changes for employers in 2020, and we're also going to focus a little bit on volunteers as well as employees of your organization. And then we also understand that many of you are in the arts area, but also in the healthcare spaces. So we'll talk about your constituencies a little bit too. So we are focusing on COVID liability really from the perspective of an organization and both its employees and volunteers and its constituents. We won't be talking about some of the other larger COVID related issues that might be on people's minds. We also are going to spend a little bit of time at the end on an update on key employment law decisions because we think that has an impact on the nonprofit community as well as what you're wrestling with COVID. And although it's not on here, it's really like one point, you know, A or B. We are going to talk a little bit about how COVID-19 has had a disproportionately adverse impact on the typically disenfranchised and marginalized communities such as people of color or LGBTQ folks or folks like that. And that matters to you both as an employer and for those of you who serve those constituencies, what they might be dealing with. So we will talk a little bit about that as well. And then most importantly, although we will leave time for questions at the end, we really want this to be as meaningful to you all as possible. And so thankfully, Ileana is going to help moderate the questions so that we can answer them in real time. And both Trevor and I will try to remember to actually stop and let Ileana give us the questions that have accumulated thus far. It's our experience that these are best served if we can take your questions when you have them. So thank you all. How about that next slide and we'll jump right into it. So this is a plug. Our marketing people would be very mad at us if we didn't have this slide in there. We have a resource page. It's hopefully easy to find, www.dorsey.com/coronavirus. And it's somewhat curated by topics on the right there you can see, but then you can also click in and do searches. And we try to put all of our webinars that folks like Trevor and I have been doing since this started onto here too, the ones that we have permission to record, and we like to post them. And it's my understanding, and I'm going to guess that Courtney and Shannon will talk about this later, that you'll have access to that stuff too, not necessarily on Dorsey's website, but we have other recordings where we have talked about some of the changes and areas even outside of employment. So we encourage you to go and check that out, and hopefully there'll be a useful resource for you. So next slide. Okay, so let's talk about what are the general requirements in Minnesota to operate safely now that we are done with our official lockdowns, which didn't always impact everybody because, of course, there were always exceptions for essential services and essential workers. But now, generally speaking, the governor's orders are such that businesses can return to work and organizations can return to operations, provided that they develop a plan to ensure that first and foremost, employees who return to work can do so safely. And then there are some specific rules that we'll get into in a little bit for depending on what type of business or organization, what type of services you do. But the first thing to remember is masks are required for all indoor activities. So if you are then going to develop a plan to make sure that you can return some of your employees and volunteer workers to work safely, and you don't have that they have to wear masks in your plan, then chances are your plan isn't going to comply with Minnesota's requirements. So we just need to point that out, that masks are required for all indoor activities here in the state of Minnesota. And then separate from that, employers are required to develop a written plan. Now they don't have to submit that plan to the government, but that has to be prepared because it has to be produced upon demand if the government asks. And so there's really no time to produce it afterwards, or try to work on it. So I know that both Trevor and I have helped folks develop plans, but there's actually a useful link on the Minnesota website, which contains a nice shell. You don't have to sort of reinvent the wheel. And I'm pretty sure the Council of Nonprofits has a link to that. Um, there's three main components to it. You have to make sure that you're screening employees for symptoms. You have to limit the number of employees that will be interacting with each other, and you have to have social distancing measures in place so that people can interact at safe distances. So that's like a very high level view, but I don't know, actually I'm going to pause for a second and see if Trevor wants to add anything to that particular part.
Nope, I was just going to make a plug for the template that is available on the Minnesota government's website. You can go find it, and it's a good gut check for, hey, what are the things we should be including in our plan. It is not the be all end all. You can certainly have different approaches as long as you're covering the basics that we have here. And so, while I want to say you can be creative, creative is probably not the right word. You can find solutions that meet your specific needs. You do have flexibility here, which is just so important with how fast the COVID-19 situation is evolving.
Yeah, that's a good point. Um, uh, it's important also to remember that in addition to the general requirement that masks are always required, employees who are able to perform their duties remotely must continue to do so under Minnesota's law. So even if you want them back, if they're able to do their jobs remotely, the Governor Walz says then they get to. And that's going to be relevant when Trevor and I talk about some of the laws that are in place with regard to some of the extra protections that were passed on the federal level for workers. Finally, for community and faith-based organizations, your plans need to include how you're going to keep your clients and your constituents or the recipients of your services, how you're going to keep them safe too. So that's an important component. And then if you are an arts organization, performances, you can actually allow the performers to take their masks off if they are clearly far away and all of the audience members are socially distanced and wearing masks, and social distancing is practiced on the stage so that the two actors or the two singers are far enough apart. Then the governor's requirements allow you to take your masks off for those performances. I actually encourage you, I think next slide might have the links. Yes, thank you. So it's really a good idea to use these links to find it, because they do really specify certain aspects of indoor activities for a wide variety of organizations. I think Minnesota, of all the states that Trevor and I are looking at, Minnesota is one of the better ones with regard to really providing templates and helping folks. It's also really important to remember that you need to follow the CDC and the OSHA, Minnesota's got links to those, and most of the other resources have links to that. And that stuff changes, as Trevor noted, that stuff changes pretty frequently as well. So liability, right? That's the title of our thing. If you are following these guidelines, then you have a good faith basis to defend yourself in any cause of action. So let's break that down for a second, because I think a lot of people are like, well, I don't want to have my employees come back and get sued, right? That's sort of the first question that people like Trevor and I get. Well, first of all, um, if you have employees and you are in compliance with Minnesota law, that means you have workers' compensation that covers your employees. And any injury or illness that occurs at work, if it occurs at work and it was caused by the work environment, is going to be covered by workers' comp. And a lot of people look at workers' comp as auto insurance and like, well, it's just a little fender bender. I don't want to report it. But that's really the wrong way to look at it. You want to report everything to workers' comp. Workers' comp is a system, and it was started at the turn of the century in the 1900s. It started as a way to alleviate employers from getting sued. And it was basically a system that said, if you have workers' comp, then you will go through that, no questions asked. So in this way, it is like auto insurance in that it is a no-fault auto insurance policy. And so it's actually a good thing, because you want the workers' comp to cover a claim. Now in Minnesota, and here's where I'm going to get Trevor to check me because I always forget this, Minnesota has not completely modified its causation requirements under workers' comp, but it has said that if you were in some sort of first responder um, uh, um, job or service provider, then if the employee thinks they got COVID at work and they happen to be, in a healthcare emergency situation, then it's probably true that it's a workers' comp claim. But everybody else is going to have to show that they didn't get it when they went to the grocery store, they got it when they came to work. And so that's really a fight for workers' comp. That's not a fight for you. But let's say that you don't want the government to cite you, or you don't want your volunteers, or you don't want your customers to sue you. Following these safe operations means that you are complying. And so then what that really means, without getting too technical, is that you're not being negligent. And so generally speaking, if you have regular insurance, not just workers' comp, but general practices and premises liability insurance, or even just a negligence lawsuit, um, having a good faith compliance with the rules that the government are putting out is the best way to shield yourself from tort claims, lawsuits that say, hey, you made me sick. Because if you're following these rules, then you didn't make that person sick, even if they caught it at um, your location. Anything else to add to that, Trevor, before I move on to the next slide?
The only thing I'll add is that it is, some of you may be thinking like, okay, well, how am I going to prove that I looked at the CDC website, a year from now when this becomes an issue? And it can be something just as easy as internal email communication saying, hey, let's make sure we check the CDC website, or a draft that says, actually, the CDC says we need to have this provision in. Something really simple that's going to show that you're taking these steps. That's going to be a really important piece to have. And it lets you put employees' minds at ease to say, look, we're checking CDC, we're checking OSHA guidance, we're staying up on this. You can kind of make it just a habit as part of your standard operating procedure to check in and see what updates there are. I think this is now the third time we've said this is a changing situation. It's changing rapidly. And so staying on top of it is, to be honest, half the battle.
That's right, and that's a really good suggestion, Trevor, because in your business plan that the state wants you have to designate that someone's responsible for making sure that everybody's complying. And one of their responsibilities can be once a month, once a week, once a whatever, check, and so that kind of documented sort of compliance and revision of protocols as the science of this pandemic evolves and we learn more about what is and is not okay. How about the next slide? Okay, so here's where I'm going to probably start talking less, and Trevor's going to start talking more because he's actually legally more knowledgeable about this stuff. Two important statutes were passed as they relate to employers and nonprofit organizations with regard to COVID, and you can see that they were enacted pretty early on. And for those of you political junkies out there, it's probably unlikely that we're going to see any more changes in the next month. But these really govern kind of the additional benefits that are available to employees and the additional requirements of employers. And the first one, FFCRA, Family First Coronavirus Response Act, it basically created two entitlements. One was a sick leave bucket, and then the other was an add-on to the family medical leave by giving emergency family and medical leave. And of course, there'll be some interesting components to that we'll get into in a minute. But that's really, in a nutshell, what that act did. It basically created a mechanism and an entitlement bucket for people to take time off as it related to specific needs within the pandemic. The other one, which neither of us are experts on, but was important to a lot of nonprofits and a lot of small businesses, was the Coronavirus Aid, Relief, and Economic Securities Act, which of course is called the CARES Act. In addition to the federal loans that a lot of folks took advantage of, it did create some additional unemployment benefits. And it had some limits. It did have some amendments to the FFCRA. So those are really the two big federal statutes that Trevor and I will be talking about for the next couple minutes. So let's go to the next slide.
Actually,
So,
Rebecca, just
oh yeah, please, Trevor.
before we get into FFCRA and some of the leave, I do think we have a question that probably pertains to some of our earlier discussions about having a panel. Sorry,
see, I said that I wasn't going to do it, and I didn't. And thank you, Trevor, for doing it. Eliana, thank you.
Yes. Okay. So An anonymous attendee is asking, should we be having people signing waivers to attend our events or health forums? Something along the lines of, I'm healthy, therefore I can attend this event.
Great question. So lots of lawyers sort of did a big sky is falling and everybody's going to get sued and you need waivers. The flip side of that fear is that waivers are generally not enforceable the way lawyers like you to think they are. So you should absolutely consider self-certifications of your employees when they arrive to things. Like when they arrive to work, they can say, I checked my temperature this morning, I haven't traveled. We do that when Trevor and I go into our office. We have to self-certify before we're allowed in the office. We have some clients in the food and agricultural business that actually do take people's temperatures and won't even let them in the building. But so however you want to make sure your employees are symptom free, you should have that kind of a method. You do not need to have them waive anything, and I recommend that you don't have them waive anything because it won't actually be legally enforceable. And as we were alluding to earlier, you actually want it to be a workers' compensation coverage issue anyway. So you want them to self-certify that they are, or you want to have some certification method. So now let's talk about your volunteers or people attending your events. It's probably going to be very difficult to enforce something that's akin to a waiver, but it is a good idea to put the rules up. Um, and because you can ask people to comply with the rules, and then you have a means in which to not be held liable for someone who violates the rules. So you can say, to attend this, opening, masks are required, and everybody must maintain a social distance of 6 feet, and by entering you agree that you have not traveled any place that's on the CDC hotspot, blah blah blah. So we do think it's a good idea to have rules and post them, and to the extent that people can, if you're selling online tickets, they can click and say I agree to follow these rules. Those kinds of certifications we think are a very good idea. We don't recommend and I won't sue you if I do get sick, because that's probably not going to be enforceable, and that's just going to undercut the rules. And so it's better to just say, here's what we want you to follow, and then hold people accountable if they don't follow them, than to have somebody waive their kind of legal rights. Trevor, anything to add?
The only thing I was going to tack on is that one of the big reasons why we say stay away from those waivers, in addition to them not really being all that enforceable, is because it sets a kind of icky tone. Icky is a formal legal word.
Very technical word.
It's a very technical word. It leaves a kind of sour taste, whether you're using it for employees or for visitors, customers, attendees. And I think at least most of the clients I've talked to find that you catch more flies with sugar or with honey. And if you can kind of put this up, as Rebecca said, as a please self-certify, please take some ownership here, and here are the rules that we expect you to follow. That gets you a little bit further than maybe a big scary waiver and wait a second, why am I releasing, and putting people's backs up.
Yep. Ileana, is that it for that question?
Yes, that is it for that question. Thank you. I appreciate it.
Oh, no, thank you. And I'm sorry I forgot to do that. And thank you, Trevor, for reminding me. Okay, so let's talk about the paid leave requirements under the FFCRA. It's important to remember that it does apply to small employers, and it applies to small nonprofit employers. So in this case, there's no distinguishing between a for-profit employer and a nonprofit employer. The distinguishing factor is less than 500 employees. And so assuming that you all have less than 500 employees, this is an entitlement that you all are required to provide to employees. There's a paid leave requirement, and there is an opportunity for you to be reimbursed for this paid leave through you can offset this when you submit your quarterly tax payments for your 941s. So when you withhold taxes on your employees and you submit those on a quarterly basis, you can offset anybody in that quarter that you have paid this benefit out to. And then it is only available if the employee cannot work and cannot telework due to a need for what's called a qualified reason. So let's go to the next slide. So the first bucket is, oops, back one maybe? Yeah, thank you. The first bucket is emergency paid sick leave. So there's a lot of gobbledygook on this slide, and hopefully the red helps. But there's basically, I always say 5 main categories of why you can get this, because the sixth is really only the Secretary of Health and Human Services gets to tell us what that category is. So it's not like your employee can say, hey, I'm in that sixth category. So it's really people who are subject to a quarantine, advised by a health provider to quarantine, experiencing symptoms and seeking a medical diagnosis, caring for an individual who's in those 3 categories, or caring for a son or daughter due to school or childcare closures. And that one we'll talk about when we get to the next bucket of entitlement as well. So those are the kind of 5 reasons, even though it's 6 reasons, because the 6th one is the human services gets to tell us other reasons. Now, what's interesting is, as we've learned more and more about COVID-19 and the ability to get tested is a little easier, and the strain on our healthcare system, though it's still very real, is less. Um, it is easier now to get the employee to get documentation or to be told by a healthcare provider, oh, you don't have symptoms, you do have symptoms. But back in April, when this first happened, the advice was, don't ask for any documentation because we don't want people running to the doctor because we only have so many tests. And unfortunately, some of that has been left over in the Department of Labor's rules, and it basically encourages employers to be flexible. But in general, they need to be able to support the fact that they meet one of these reasons. The other point is that it is 80 hours of paid sick leave, assuming that you work a 40-hour full-time job. If you're part-time, then there's a complicated system of kind of how you track those hours. And I'm going to stop there and let Trevor talk about how you get capped and how you get reimbursed. So Trevor, can you take that part?
Yeah, so Rebecca said we tend to think of this as really 5 different reasons for leave, because that 6th reason, the Secretary of Health and Human Services, we haven't seen anything on that front. We don't really know what that would be. So in addition to thinking of it as 5 different types, I tend to break it down, as you can see on the slide here, into really 2 different categories of those types. If you're in the first 3 reasons, which tend to be if you yourself are experiencing some event, then your paid leave is 100% of your regular pay up to $511 per day. So it may end up being less than $511 if that is what 100% of your regular pay is, or this is what employees are entitled to receive. Again, the $5,110 in the aggregate, that'll change depending on if the employee is part-time or full-time, but we're assuming a full-time employee here. If you're in the second 3 reasons, or really the second 2 reasons, caring for an individual who's subject to quarantine, or the big one is caring for a son or daughter due to a school closure. I think that's the one that at least I've seen the most of. You get kind of a different pay structure. You get 100% of your regular pay, or $200 a day. And actually, I think we have a typo there. I don't think it's 100% of your regular pay. It's 2/3 of your regular pay.
Yep, sorry about that.
So it's 2/3 of your regular pay, or capped at $200 a day. I want to make a very quick plug before we go on to the next page. First of all, this stuff is confusing. It was confusing when it came out, and it's still confusing today, seven months later. That's where having, picking up the phone and calling somebody who works in this, whether that's an employment lawyer or whether that's an experienced HR professional, is helpful. I will also say that the Department of Labor, the US Department of Labor, has a really helpful FAQ document. It's written in plain English, it's broken down by categories, it's question answer, and it's one of my go-to resources, and it'll really help you understand these questions if you're still grappling with them. So that's a good one to note that I wanted to make a quick plug for. If it seems confusing, it is. There are resources available to help break it down and make it manageable.
Thanks, Trevor. Let's go to the next slide, Shannon. So the second entitlement bucket that came out of the FFCRA was this expansion of FMLA, and expanded in a couple different ways. First, it applied to people who may not ordinarily be covered by FMLA because it's going to apply to everybody with less than 500 employees, and the FMLA only covers employers of a certain size, which I now forget, but I think it's 100. There could be 70. I always get those confused. And then it adds a new reason, which is this caring for the son or daughter. And this is another example of where the Department of Labor's website is good, but also has evolved because, you know, in the first round of this, the schools were absolutely clearly closed. Now, some schools have an opt-in. You can send your kid in, but we really hope a lot of you choose to keep your kid home for distance learning. And then some schools are there's it's confusing whether or not somebody is caring for their son or daughter because their school is closed. So again, I encourage you to talk to somebody but that's the only reason for this. So it's not caring for somebody who's sick. That was the other bucket. And what this does is basically say that you can take up to 12 weeks of leave, which is the ordinary FMLA bucket, but you can also get paid for the last 10 of those 12 weeks. So the first 2 weeks are unpaid, but recall that you might actually have 2 weeks of pay from that prior bucket. But for sure, from weeks 3 through 12, if you're still needing it, you get 2/3 of your pay, capped at the $200. So this one is a little narrower than the first one, but it actually lasts longer. And this one too is subject, you can get reimbursed for this one too, right, Trevor?
Yep.
I think, yep, okay.
Yep. And these two, it's important to remember that these two they work together. The paid sick leave that we were just talking about and this Emergency Family and Medical Leave Act, they work together, but they're different forms of leave. And so it's important to analyze them differently. One important thing to note here is that this 12 weeks of leave that we're talking about for this emergency FMLA leave, that takes away from your pool, and this is going to be my lead into Ileana, who I think has a Q&A for us. That dips into your pool of FMLA leave. So it is one 12-week pool of FMLA leave. Some of it might be paid under this new version, but if an employee has already used all of their FMLA leave, they don't have any left over to be able to use for this expanded form of leave. So this is not creating another 12 weeks on top of that.
Great. And thanks, Ileana.
Yeah, so we have a question in the chat. Shelly has asked, are the 80 hours a one-time thing? I'm assuming they said the sick leave, not the FMLA. So if an employee qualifies for a leave once, but then later qualifies again, but hasn't used up the 80 hours in that first 2-week period, can they use a balance?
So yes, so it's 80 hours between back in April and December 31st. That's what we know now. So and so if they only used 40 hours back in June and now here we are in October, they still have 40 hours. But if they used 80 hours up back in April, they do not have another 80 hours. It is a one bucket of 80 hours, which expires on 12 right now, at least unless they change the law. It expires on 12/31. So Trevor, did you want to correct me? Did I get that wrong?
Nope, and it's one 80-hour bucket for all of those reasons. You don't get
Yes.
80 hours for reason 1 and reason 2 and reason 3 and reason 4, which is that's a really great question. And it's a really important one to note because you don't want to pay out all of those 80 hours and then submit for reimbursement and have the IRS deny you and say, no, we're not going to give that back to you because you botched it. It's a good question.
That's right. And so that sort of kind of tying it back to our title. So that's another area that the employer needs to be careful of because there's two levels of liability, if you will. There's the liability that an employee might make a claim that they did not get this entitlement. And that would be no different than them making a claim in any other ordinary employment context, right? They'd go to the Department of Labor because that's who enforces this law. And they would say, I'm not getting my paid sick time or I'm not getting the FMLA that I'm entitled to. And then the penalty scheme is the same as another wage and hour violation or an FMLA violation. But the other penalty or liability, if you will, is that that the IRS will not allow you to offset. And so you're going to end up being out this money, which I think is probably the scarier one for folks on in this audience, right? Because your dollars are precious already. And so it would be difficult for you if you had to give out this money and then not do it correctly in order to get reimbursed properly. Any other ones like that? Okay, great. Thanks. Let's go to the next slide. Um, so um, the most recent study that I've seen was McKinsey. They did a report and they started tracking things since I want to say April. But there are other studies too, and the New York Times has been publishing a lot of them. And I think one of them is the University of Minnesota was responsible for getting some of the information out there. But the gist is, and this is relevant to a lot of you all who serve the underserved community, is that on almost every level that you can think about the impact of COVID-19, it is disproportionately adverse on the um, Black, Indigenous, and people of color communities. So first, there is a higher representation of folks who identify as Black, Indigenous, or of color in essential worker positions. So some of them have never, ever actually even been able to quarantine. They have been on the front line in the exposure right from the get-go. So they have been at risk as soon as possible. The next uh, area in which I'm going to address is that this community tends to have less access to childcare needs because so much of our childcare is in the traditional, um, we'll call it 7 a.m. to 5 p.m. window. When we were getting ready for this, Trevor made a joke about how horrible it is to miss the 5 o'clock pickup because you sort of have to leave, a ton extra money when you come get your kid. Well, if you're working in an essential worker position that's the night shift, where is your childcare anyway? You've already had childcare issues. And so then it just got sort of overburdened because childcare centers were shut down before they could figure out how to operate, not all of them, but many, safely. And so there was already a problem in certain communities with access to meaningful childcare. And I'm sure I don't have to tell many of the audience members that, but that became sort of heightened as a problem as folks were shutting down or not knowing how to operate safely and not being able to sort of provide that care. And then with regard to school-age children who are being forced into distance learning, there is a real problem with certain areas not having access to reliable internet, and then many families within communities not having access to reliable internet. And many folks who are marginalized or at the lower ends of our socioeconomic structures would go to places like the library to get their internet. And of course, the library is closed. This has been very difficult, and there's a lot less people who are in essential worker positions can do their work remotely anyway. So many people have had to keep leaving their homes. Their children have been not able to go to school, and this has just been a double impact. I am not a healthcare professional or a scientist, but the studies that I have been looking at, there have been sections on the actual impact of the disease, and that relates to sort of the access to our healthcare systems. I think many of you all know that many communities are underserved with regard to the healthcare system, and even if they have access to the same healthcare system, they're often treated differently when they actually get into the healthcare system because of many of the biases and problems of systemic racism. Um, but the gaps in the federal protective legislation really underscore this because as we just discussed with that emergency child care, you can take leave and you can sort of take care of your kid while you're working from home. And if you can work from home, you must work from home. But if you can't work from home, who's going to take care of your kid? And can you really survive on 2/3 of your salary when you're already at the lower end of the salary structure? So these are just some examples of how this pandemic is heightening the obvious disparate impact of most of our structures here in the U.S. with regard to systemic racism and the unequal access to much needed social resources. I'm going to pause there in case people have specific questions about this issue.
Yes, someone does have a question. They said, going back to FMLA, if I can, does this legislation expire?
Mm. So the FFCRA does expire on 12/31. So that would be both the 80 hours of leave and the extra leave, the 80 hours of paid sick time and then the extra FMLA leave.
As of right now.
Yes, right. I am banking on President Trump's most recent tweet of related to this, which is we will not be negotiating a deal until after Election Day. Okay, great. Let's go on to the next slide. Okay, Trevor, you want to take this one?
Sure. So before we jump in with all the scary things that can go wrong for employers with COVID, I should note that Rebecca and I are lawyers, and so it's our job to look out for what the scary stuff is. So we're not trying to scare anybody. We're trying to prepare you. And some of what we're doing right now is a little bit of guesswork because we don't know what the lawsuits are going to be, what the liability is going to be, but we can spot some trouble areas. And this is trouble spot number one for us. I've fielded a lot of questions to say, well, I've heard a lot about this 50 employer limit, and I'm below 50 employees. This 50 employee limit. I'm below 50 employees, so I'm exempt from all these leave laws that we've been talking about, right? And the answer is kind of, but for a very limited limited basis. And so if you think you are, you should talk to an employment lawyer. You should talk to an HR expert in this field. Don't just assume, oh, I'm under 50 employees, so I'm safe. There are a couple limited exceptions, and they have to do with the paid leave benefits under the Family Medical Leave Act extension that we were talking about for caring for a son or daughter due to school closure. There aren't exceptions, though, for any of the other 5 categories that we talked about. So be very careful if the business plan is, oh, we're under 50 employees, so I don't have to pay attention to this. Be very, very careful with that because that's not entirely accurate. Not accurate at all, I should say.
And I should note that, the purpose, sometimes it's helpful when you have all these confusing and hastily enacted statutes. Sometimes it's helpful to understand the purpose. And the purpose was to help people stay home and not have an economic crisis because we didn't understand how the disease could be transmitted, right? And so that's why if you're sick, it's like we still want them to have the leave, right? If the individual employee is sick, then the thumb is on the scale to let them have this 80 hours of leave. If it's to take care, no one's sick, but the school's closed, then there's kind of this thumb, the scale tips back towards the employer's burden and whether it's hard for them to give that leave. Next slide. Okay, so I talked about this a little bit at the beginning. Can I require documentation from my employees? The answer is yes. Yes, you can. Um, and, and it's important too for that whole, if you get audited when the IRS says, why did you pay this out, right? So it's good to have this documentation because it, A, will help keep you and your employees kind of on the same page with who's getting this leave and who isn't. But it'd also be helpful if the IRS comes asking later, like, why did you give this? So if people need the sick leave, you can ask for them to document why. It's great if they have a doctor's note, but if they don't, you should accept them certifying that they cannot come to work for one of those reasons, or they can't telework, which is probably obvious to many of the positions where people would need it. If they need the extended family leave, the emergency family extension, then they need to talk about sort of where the school or the daycare was, in order to make sure that you've got that sort of documented so that it can be proven that it was closed. There's a question, I don't know if we have a question yet, but there was a question that we were asked recently, which was, well, my school said you can send your kid to school or you can leave them home. So, well, actually, it was a client who said an employee was making the choice to use the remote learning, but the school was open. Well, I think there's an FAQ right on that in that helpful website that Trevor talked about, which is that even if the school is partially open and the parent chose the remote option, then that would still entitle them to take care of that would still entitle them to this leave under this statute. Potential landmine in this area is you get this documentation, but you want to make sure that you're not getting too much documentation because individuals have an expectation of privacy, and in Minnesota, a right to privacy with regard to their medical records and how much they need to disclose. They need to disclose enough for you to be confident that they are entitled to the leave, but they don't need to disclose um, every medical record that proves that up. I think there's one more landmine, right? Okay, let's do that one. Next slide. You want to do this one, Trevor?
Sure. Uh, this is just kind of a good closing point for a lot of the leave discussions that we've had. This is a great time with the shift to remote work. This is a great time to take a look at how your organization approaches teleworking and remote working. Remember that the trigger for all of the leave that we've talked about today, the 80 hours or the 12 weeks, is the employee has to be unable to work or telework. So Rebecca and I will never qualify for this leave because we can both telework pretty easily. But keep in mind that that's going to be a case-specific analysis. You can't just say our organization has a no remote work policy. You need to actually dig into that now and take a look and see, can this employee, can these positions telework, can they not telework? And this is really a good time to dust off those policies, or if you don't have a policy, to think about, okay, what's our approach going to be, not only for COVID, but maybe, knock on wood, if things return to normal, what our work from home policy or arrangement or approach is going to look like. I will make a very quick plug for wage and hour policies. Please remember that if you have non-exempt employees who need to be paid overtime after 40 hours, who are tracking their hourly time, even if they're working from home, the temptation is so high for them to be a little less accurate or kind of fudge their numbers. That is a nightmare waiting to happen. Those employees, non-exempt employees, need to be really, really diligent about tracking their hours, even if they're teleworking. It's a little bit more on them because, if they're coming into the office, it's a lot easier to track hours. So make a diligent effort to make sure that all employees, but particularly those non-exempt employees, are not going to get into trouble in terms of overtime laws.
Thank you. So I think we might have some questions here because we have another section that we're moving to. So let's maybe take some questions here.
Yeah, so we have one question, and it says, if they disclose too much info, what would you recommend for protecting that health info? Can you just delete, or do you need something more?
Great question. So first, I'm going to say something that always sort of makes my HR clients furrow their brows at me. Unless you are actually a healthcare provider and or you're self-insuring your employees for medical plans, chances are you are not covered by HIPAA. But people tend to think, oh, I have medical information from my employee and it's HIPAA. Medical information from your employee to you, unless of course you got it from the plan, um, is not covered by HIPAA. But it is covered by Minnesota's right to privacy of that, and employees tend to have a reasonable expectation of privacy. And even on the federal level, like with the Americans with Disabilities Act, there's all kinds of recommendations for keeping medical information separate from a personnel file. So first and foremost, if somebody discloses it and it's their own health information, we don't have to worry about any of that because they've just voluntarily disclosed it. But you don't necessarily want to keep it on file because now you're kind of in complicit with that. So I recommend only keeping what you need and destroying or telling them, oh, I don't need all of this. Like if they tell you verbally, say thanks. Don't need all that, right? If they actually literally submit the results of their COVID test, you don't need to retain it. You can say, thanks for showing that to me, take it back. So definitely deleting if people have too much. But if you already are having medical information, because maybe you actually have medical files for other reasons, like maybe you are in the healthcare space and you check your folks for TB once a year or whatever, you could keep that in the medical file, and then that's sort of secure and not doesn't have all the access. So if you already maintain a separate medical file from your personnel file, I would say you could keep it there. But otherwise, I think you can delete what you don't need. Trevor, do you have any different thoughts on that?
No, I think that's it's not information we want. So thank
Yeah.
you for showing it. We're going to give it back to you. Is a great approach.
Yeah. Okay. Okay, thanks, Alana. So let's go to the next slide because I think that's the cases. Yes, great. So I'm going to ask Trevor to talk about a couple different cases. We still want your questions, as I think Courtney might have said in the chat or the Q&A, so please keep them coming. But this is not quite COVID related, but I think it's important for you all. So Trevor, take it away.
Yeah, so we wanted to round out our presentation today with just some notes on some really important Minnesota Supreme Court decisions and United States Supreme Court decisions. And the reason why this is important in the context of COVID is because it's so easy to get tunnel vision and to say, I got to focus on this paid leave, and I got to focus on keeping employees safe, and I got this governor's plan that I got to have in place. And all of the other employment laws are still out there. They still exist, and you still have to comply with them. And there have been some important changes. So you don't want to get, as tempting as it is, you don't want to get tunnel vision with COVID and have something jump out at you. So the first decision that we wanted to talk about today is Megan Abel versus Abbott Northwestern Hospital. And this is a Minnesota Supreme Court decision from earlier July this year. And we've got a couple notes on the facts up on the screen, so I won't go into too much detail on the facts. I also need to be a little bit careful because Dorsey, our law firm, is handling this matter, and it's going to still continue on, so I don't want to talk about it in too great a detail. But the headline here, and the reason why we think it's important, particularly for this audience to know, is that there was an unpaid practicum student. So she was a graduate student, and she entered into a practicum program at a Abbott Northwestern Hospital, local medical facility. And then she was subjected to harassment by her clinical supervisor. She alleges she was subjected to harassment by her supervisor. And some of the conduct that she alleges, some of the comments are here. She was referred to as the graduate student of color, or the brown one. Some flirtatious correspondence and inappropriate touching. All things that I think all of us on this call or on this webinar can agree are not appropriate. And the plaintiff complained, and eventually this proceeds to a lawsuit here in Hennepin County District Court. And one of the issues in this case, there are three issues that I'm going to talk about, but one of the issues is, what do we do with this? Because this is an unpaid practicum student. Is she an employee for purposes of the Minnesota Human Rights Act? Is she allowed to assert claims for harassment? Because she's not technically an employee. And for a long time, the answer we kind of all thought was no, that those statutes, those laws protect employees and let them bring claims against their employers. And so unpaid practicum students don't fit that bill. If we can go to the next slide. The three kind of important points, and I'm going to talk about number one and number three very briefly, because they're more kind of legal points, but they're good ones to note. Number two is the big one now. The Supreme Court says, first of all, we got to figure out when the limitations period starts for bringing these kinds of claims. So this was what we call a hostile work environment, a harassment claim. And so it's ongoing. And under Minnesota law, you have 1 year to start a lawsuit, but it's a little tough to figure out, when does that 1 year start? Is it the very first time that an inappropriate comment occurs? Is it the latest inappropriate comment, the last time that an inappropriate comment occurs? Is it somewhere in between? And so the Supreme Court kind of doesn't give us a good answer. They just confirm, yep, you got 1 year from the date of a discriminatory practice. And so our takeaway from that is, you got to document, figure out when events occurred, figure out what the response to it was, because that's all going to become important later. Number two is the big reason why we wanted to talk about this case, because it's not too far of a stretch to figure out, okay, if this is how we're dealing with unpaid practicum students, the same is probably going to be true for interns. Maybe it's even going to be true for volunteers who are providing, services, things that look like they might be employment services. All of these individuals can now bring claims underneath the Minnesota Human Rights Act for things that we would technically think of as employment discrimination. And so it's important to be aware of this. If your organization relies on interns, if your organization relies on volunteers, we need to be careful about our approach to those employees. Obviously, we want to foster respectful workplaces, and so the intimidation, harassment, inappropriate conduct is never going to be okay in the workplace. But we got to pay special attention to it now in 2020, given that the Minnesota Supreme Court has kind of tipped its hand to say that these people are going to qualify for protection under Minnesota's employment laws. And then the third point that we have here is, for a long time, the law in Minnesota was that the Minnesota Human Rights Act, that's the only way that employees can sue their employers for things like harassment, discrimination, retaliation. And in this case, Megan Abel, the plaintiff, the practicum student, and her attorneys also tried a negligence claim. And so a lot of employment lawyers said, well, you can't do that. And the Minnesota Supreme Court said, yeah, you can. We're going to let you do that. And the reason why we think this is an important takeaway is because it shows a shift, at least in Minnesota, but probably also for courts around the country, to be a little bit more forgiving with employees. And we're going to take this seriously. It's 2020. We're going to take harassment. We're going to take discrimination seriously, and we're going to give employees access to the courts to talk about those issues and to resolve those issues, and to potentially hold employers liable for those issues. So you can see our tip for employers is to take complaints about harassment very seriously. I'm of course not suggesting that anybody wouldn't take those seriously, but it's more important than ever now to take those complaints seriously, show what you did in response to those complaints, and to take measures to protect the complaining employee.
So it looks like we might have a couple questions, so we'll take those.
Yeah, so we have one question, and it asks, can you provide a quick overview of issues you'd recommend a nonprofit consider when trying to decide when return to in-person programming, and do volunteers have special rights like employees? And before you answer, I do want to call out that it is about 3 minutes until we are done. So you do have any final questions you want to ask, please put those in the chat. Or the Q&A box.
Okay. So I'll take the first part of that question, and then I'll let Trevor take the second part since he's very familiar with this decision. And I think the second question goes to that. So I think that with regard to returning to performances and returning to public kind of events and programming, I think you have to take a risk analysis with regard to what are the risks of not providing certain services versus what are the risks to making sure people are healthy. So for many people who were able to and took quarantining seriously and really were home, there's real mental health concerns that we don't know yet how they're going to be materialized in the long term. We have a whole generation, or maybe two generations of children who have basically not had social interactions, which is, we all know, a core part of healthy childhood development, right? And so there's a level in which perhaps if you can find a way to implement the services or give the performances that you do safely, that the mental health and the actual other kind of health benefits outweigh certain risks. I think that's sort of, to me, the biggest balancing act that folks should take. I think, as Trevor and I said earlier, pay attention to the CDC and the OSHA and the Minnesota governor's websites, because they're going to give you the kind of current evolution of science in terms of what is and what isn't safe. But then you have to think about your mission. We have a client who does performances, and the performances are somewhat therapeutic for the folks who are the volunteer actors and performers. And so in a way, they needed to go back maybe sooner than another musical group would go back to performances, because they felt like the health and well-being of the client base, which were also the volunteer performers, was important to them. So they really looked into how they could do that safely. Whereas other other of our art nonprofits have felt like they could transition into the Zoom world and they could still get their music out there via Zoom. So they didn't feel the need to have live performances as quickly, because it was really more about sharing the music as opposed to the performers needing to be together with each other. So that's a calculus I think you have to make yourself.
Alrighty, and then quickly, Trevor, did you want to answer the second part of the question, which is, do volunteers have special rights like employees?
Yeah, and sorry, I think I did drop off there, but I'm back. So if I put my lawyer hat on, the answer is, I don't really know, probably. But if I take my lawyer hat off and put my practical hat on, the answer is yes. I cannot give you any real persuasive answer for treating volunteers differently than you do as employees and have that be your starting point. There may be some specific instances where we could talk about needing to set different rules, but as a general matter, it is just best practice in 2020 and beyond to make sure that your workspace for employees, volunteers, everybody is free from discrimination, is free from harassment, and to take steps and be proactive on that front.
Nice. Awesome. Thank you so much. And then do you quickly want to have like closing words, Rebecca and Trevor, and then I will close us out.
So that I don't make Shannon have a heart attack and ruin their day, I'm just going to quickly say thank you all for the opportunity. You can find Trevor and me on Dorsey's website, and so we're happy to take follow-up questions that way.
Awesome. Thank you all so much. I appreciate everyone being here today and spending your afternoon with us. Thank you, Rebecca and Trevor, for your presentation. Lots of great information. As Shannon has said in the chat, the recording and the slides will be available within the next day on the Minnesota Council of Nonprofits COVID-19 page. And before we log off, I just want to let you know that MCN is hosting another a free virtual event on October 12th that is all about redistricting and why it's important now that the census is coming to an end. You can check that out in the on our events page, and I believe Shannon put that in the chat. So with that, I will let you all go enjoy the rest of your afternoon. I hope you all get outside. It's really pretty out. I think it's about 70 degrees and sunny, at least in Minneapolis. So I hope if you're in a different area, I hope that's the weather for you as well. And with that, thank you so much. Have a great day, all.